recording has started. Please do not hesitate to continue interacting with the platform and all the other colleagues. So, Mambo, Koma Sava, Hola, Tobela, Sanbonani, good morning, good afternoon, good evening. Welcome, everybody. And thank you all for joining us this evening. For the next hour or so, I envy anybody in warmer temperatures than in mine, and I empathize with those in the same cold temperatures as mine. Today, we are in Malawi, and this is the network of DPOs for Africa, all over Africa. We stand by business, we stand by our words, and we weather the storm. So welcome, everybody. As I said, today we're in Malawi, talking about the Malawi Data Protection Act, which came into force in 2024 with Malawi Communications Regulatory Authority, better known as MACRA, designated as a data protection authority a few months just after the promulgation of the Act. The Act emphasizes lawful, fair, transparent processing, data protection principles, records and governance, security safeguards, breach notification, complaints, compliance order, everything else that you know in other data protection laws, including your own, as well as regulatory enforcement. So tonight, we are focusing on the enforcement provisions of the Act. But before we get there, let me tell you about my guest, Mr. Daniel Chiwoni. He is a lawyer by profession with 19 years of legal experience, 14 of which have been in the information and communications technology sector. His areas of expertise include privacy and personal data protection, internet governance, ICT law, and regulation. He holds a master's degree in information technology and telecommunications law from the Strathclyde University in Scotland, and a bachelor's of law degree, LLB, from the University of Malawi. Other than being available here, he is here tonight because he currently serves as the head of data protection at MACRA, which is, as I said, the designated protection authority in Malawi. He's been in this position since January 2025 and is responsible for overseeing and enforcing the country's data protection legal framework, or at least that's what the manner that he sums it up in. I'm sure you'll agree with me that your work is not that cut and dry. Muribanje, and welcome, Chiwoni.
Ziko Mwambiri, and I'm very happy to be here.
Thank you. How are you doing this evening?
I'm all right. It has been quite a hectic day today, but everything is good, and I hope you're well that side.
We are well, and we are cold, but we soldier on.
Yes, yes.
I'm sure Malawi is not much warmer than South Africa, so I empathize with you too, and thank you for making the time.
It's a little bit cold.
Mm-hmm. So yes. You've been in office for 18 months now. How has it been in the hot seat, your highest highs and your lowest lows?
Yes, it has been quite a journey. These are new issues, data protection are new issues, I think, particularly in Malawi. So it has been quite a journey, one of learning and also growth. But we have been able to do a number of things. As you know, data protection is, the law was just enacted in 2024. And we had really to start from scratch, building the institution from the ground up, and also implementing a new regulatory framework. But we have been able to move, and I think achieve several milestones. There have been also some challenges here and there, but on the whole, it has been a positive experience. In the first year, we are looking so much at awareness and the sensitization. So we were able to see how quickly awareness grew. I think that's one of our highlights. We were able to successfully hold 2 privacy symposiums this year as well as last year. We did them during the data privacy weeks. Then we have also been able to do awareness campaigns across the country, and also trainings, individualized trainings for institutions on data privacy and data protection. But we do recognize that there's more to be done on this. I think awareness work can never be done. Another highlight that I can point out too is that there has been positive engagement particularly from the private sector. They've been very willing to come to us to engage, even when we were not fully ready as a DPA. But they did come and asking what do they have to do to comply or to be compliant with the new legislation. So that was quite positive from coming in from the private sector, and we have been able to partner with them and be with them along the journey, and them also being with us along the journey in terms of implementing our legislation. Ironically, I think the biggest challenge again remains awareness. It's the levels of awareness are still quite low, and we just established this during this week. This week we are doing consultations on registration fees for data controllers and data processors of significant importance. So what we have observed is that there's still need for awareness. For example, when we posted our proposed fees on our websites and maybe social media platforms, the comments that we received there completely unrelated to data protection. Some would ask why are their internet data bundles very expensive? What is MACRA? Now MACRA, because we are two hats as a communications regulator and as well as a data protection authority. So they are asking why is MACRA as a communications regulator allowing internet data bundles to be expensive? So we noticed that gap, and I was asking my team that, are we doing enough if these are the questions that we are receiving? So yes, we still need to work on that, and again, from the data controllers and data processors themselves, some do confuse our mandate with other consumer protection organizations. So we really need to do that awareness and continue with that messaging. So yes, I think that has been the journey so far.
No, it is quite a lot compared to other regulators that started long after or long before you. So I can tell you without a doubt that awareness creation is a lifelong exercise that you'll be conducting. And I'm pleased to hear of the private sector partnership and basically walking this journey with you and you walking the journey with them, because you'll never be able to do this on your own, and they will never be able to do this on their own as well. The partnership is quite important. So I guess that Malawians are not about to be exercising their data subject rights anytime soon, because there's still a lot of awareness that is lacking. And I can assure you as well, it's the same situation in South Africa. It's the same situation in Eswatini, where people will be asking about something totally different out of the authority's mandate. But it is not just your issue to resolve, but maybe it's the other regulators' issue. So maybe MACRA in their core, before they took on the Data Protection Act, didn't do enough to educate people about their mandate as well as the other consumers.
Yes.
So on that private sector bandwagon, so there are quite a few multinationals operating in Malawi who are themselves subject to data protection laws in the countries where they are headquartered. I almost want to feel that, or rather my opinion is that they should be a lot more compliant with the Malawian Data Protection Act? And have they assisted you in any way? I know we've got Stanbic or Standard Bank in the area.
Yes, yes, we do have Standard Bank, as well as other nationals. Yeah, they are here. Yes, and from them, yes, they have been. I can say one of the champions. The advantage which they have is that they are already exposed to data protection legal frameworks like the GDPR and the other frameworks in the countries that they operate in. So I can say that they did have a headway compared to their local counterparts. It started compared to the local companies. And in terms of compliance, they were a little bit further than than the local companies. But we also did recognize that our legislation is a little bit different, yes, from some of the frameworks. So they still have to comply with some of the particular requirements that apply to Malawi. But on the whole, they were quite conversant with the issues, and for them, they are quite ahead in terms of the compliance journey as compared to the others. But the others are also coming along, and they have been actively engaging us, asking us to speak to their boards, to their executive management, and to conduct trainings on data protection. So the locals I think they're catching up, and I think the way ahead and the road ahead looks promising.
No, that's good. You spoke that you said that the Malawian Data Protection Act is not exactly the same as all the others. And one difference that I have noted, and you actually mentioned it this evening, is significant data controllers. How do you define significant data controllers, just for the benefit of the audience?
Yes. So for us, we have defined data controllers and data processors of significant importance as those entities, one, that are processing personal data of more than 10,000 data subjects. So if you have got those volumes of personal information, then you will be deemed as a data controller and data processor of significant importance. And again, even though you may not have 10,000 or more than 10,000 data subjects, you may still be deemed as a data controller and data processor of significant importance if you are processing information that we deem to be significant to the economy, security, and the society of Malawi. So you still be required to register, because we're not registering each and every data controller and data processor. Only those that are deemed to be of significant importance are those that are required to register. So yes, some may ask or may question, so how would you define data, based on data that is significant to the economy, society, or security of Malawi? So we have tried to come up with regulations on that. Just to clarify, so we're looking at, it's a whole list, but we're looking at financial information, health information, tourism information, so on and so forth. So just to provide clarity on that one.
Okay. And this has nothing to do with their turnover?
At the moment, no. But the turnover now is coming in on the proposed fees, and it has sparked a huge amount of debate from the data controllers and data processors. They're asking,
imagine?
why do you want to punish us for the money that we're making? Because the fees will be based on turnover. And I'm happy that we have got data DPOs from other jurisdictions. Maybe we can share experiences in terms of how the fees in their countries are being determined, and we can also learn from there.
Yes. So DPOs, you've heard the call to action. Please just include that in the comments, and we will share those with Mr. Chiwone, and you've contributed to advancement of data protection in Malawi, including regulation.
Yes.
So, Mr. Chiwone, the other question is that, as you are creating awareness and speaking to data controllers throughout Malawi, we found that many data controllers consider compliance with the Act to be the registration, the policies, your basic general awareness training. When assessing for accountability, what evidence would you be expecting that a controller or a processor has moved beyond policy adoption into operational compliance?
Yes. So on that one, I think we can be guided by what our act says. Basically, it requires the institutions to have what is called a record of processing activities. So that one shows the kind of data that you're processing, any processing that is being done as regards to the data. So if you are able to show a ROPA in short, then I think you'll be deemed compliant. Then we're also looking at you have a privacy impact assessments, the data protection impact assessments. So if you're able to show that where necessary, then that will be deemed to be compliant. Have you documented your risks? Have you identified your lawful basis for processing personal data? What breach response procedures do you have? If you can demonstrate evidence of those, then I think you'll be deemed to be compliant with the Act.
So when you eventually go into organizations, those are the first few documents that you'll be looking at, along with the obviously the policies and the training registers, etc.
Yes, yes.
And then just on that one, when I know we are going ahead, but when you do go into institutions, right? How important is that in terms of accountability, that tone from the top, for you to be meeting with the leadership of the organization on inspection, not on their invitation?
Yeah. Yes, so the tone from the top is very important, because if top and senior leadership places data protection at the fore of their business, then I think the rest will follow. So leadership is very important, and whenever we're engaging an institution, we have tried to talk to the leadership, gauge their understanding and their commitment. And so far, what I've seen is they are really looking at the compliance. So yeah, we have been encouraged as a DPA in Malawi in that regard.
And turning the coin, how's your interaction been with the public sector, especially the ministries?
Yes, luckily for us, for the ministry, they are quite interested in data protection. So that has been a very good thing for us. The challenge has been with the public sector as a whole. Yes, so at the moment, there are certain departments and ministries that these issues are still quite new to them. They're yet to get there, and there is a lot of work to be done in that regard. And what we intend to do is to have a systematic approach in terms of how we engage them. How to bring them to the table, because that can also be difficult sometimes. Just getting to come to a discussion with us. So we are looking at having engagements with them through their leaderships, and see how they can come to the table. I think that has been the experience with the public sector. And when I talk to my counterparts in other countries, I think that has also been the experience as well.
Yes, that's why I asked with such a big smile on my face. It's a universal challenge, and
Yes,
one that is blanketed by resources and lack
correct,
of human and knowledge resources from the state, because
correct.
truly they do not pay as well as private sector, and private sector needs those people as well.
Yes, correct.
Yeah, yeah. So
maybe just before we move from that, the engagements that we have been having this week have been quite interesting. So the fees, we have segregated them. For the public sector, we have picked them at a lower scale. So some of the comments that were coming in is were that why is the public sector being treated with kid gloves? Why are you expecting us to pay a lot when you are you want the public sector to pay less? So those are the discussions that we have been having.
but what we don't realize as private sector is that the more public sector pays, the higher our taxes increase. Right?
Poor records management. Then again, in terms of identifying the correct legal basis for processing personal data. So that has been an issue which I think we may have to focus on.
And do you find that a lot of controllers rely on consent for everything?
Yes, yes. So you find, yeah. So they may say that, but in this case, consent does not apply. So how do you go about it? So we try to explain that consent, yes, is very important, but you can also lie on other legal basis, but you must be able to justify them. Yes, if you cannot justify them, you have a problem.
So I think whilst you've been engaging in a lot of creation of awareness and training. I know that you've trained DPOs as well, not just the data controllers and processors, and you're out a lot in there. I suppose the next phase prior to enforcement will be assessment. Is there an end date to where we are now, and you actually will start enforcing, however likely?
Yes. So the act itself, it did provide for some timelines, and unfortunately, we haven't been able to meet those timelines for most. So for data controllers and data processors of significant importance, it gave us 6 months for them to be in complete alignment with the act. The rest of the data processors and data controllers, it gave us 24 months. We have observed that there's still a lot to be done because even for the data controllers of significant importance, we haven't been able to complete with the registration process because we have delayed with them with the issue of registration fees. But we have said that we cannot have a grace period forever. So we'll be putting in place some new timelines where we think that I think we have done enough sensitization, we have done enough awareness. Now we need to come in, do assessments, do audits, and then follow up with the enforcement where necessary.
Do you foresee a situation where you would have mock enforcement on site inspections?
Yes, yes. So yes, we'll have on-site inspections. But when we come to the actual orders themselves, then it's a process. We'll have to give them a compliance notice, and if there's no compliance, then the action follows.
Okay, and from there, would the authority just move quickly from assessment and issue an order based on perhaps weak security controls or untested breach procedures, even poor cooperation or lack of cooperation from the data controller?
Yes, yes. So yes, all those may come into play. So we come in, we assess, and we find that there are compliance gaps, then yeah, we have to take action. In some cases, it may be just an issue of providing guidance that this is what you need to do. In cases where guidance has been provided, but they are repeated infractions, then we have to put in place measure that will compel compliance. It can be penalties, it can be orders that you cease processing, and other instruments that the Act has given us.
So
Yes.
you can't just jump in and say, this is just too bad, we cannot go through remediation, immediately to an enforcement order. Like Eswatini, I think within a few months of establishment, they had already issued 3 enforcement orders that I'm aware of, although
Wow.
they didn't issue a fine or
Yeah.
any penalty, it was just an enforcement order.
Yeah. Wow. No, that was quite quick. That was quite quick. For us, we said perhaps let's do the awareness first, then we start with the audits and the enforcement.
Okay, okay. So while you are thinking about it there, what would you consider as, for enforcement, more damaging during enforcement as a result of a data breach, right? Security compromise in other jurisdictions. Would it be the original incident, the organization's inability to explain what happened? How would you assess a damaging?
Yes, I think what would be more damaging and more worrying is where you cannot explain how the breach occurred. So you must be able to explain how the breach occurred, what corrective measures have been put in place, what security arrangements were there in the first place. When we were doing our guidelines, because of developed compliance guidelines on data breaches, there was an argument whether a data breach raises a prima facie case of non-compliance. So we had quite a debate on that one, but we said that a data breach on its own is not an issue of non-compliance, but where there has been inadequate security measures as required by our legislation, then that's an issue that we have to look at. So I think institutions should be able to look at whether they put in place adequate security measures. If yes, what were those measures, and have we tested our security, our data breach responses, so on and so forth. So those are the issues that we'll look at and see if there has been an issue of non-compliance. Have we notified the regulator within the stipulated timelines? Have we notified the data subjects within the stipulated timelines? If not, why haven't we done so? So those are the issues that we'll be looking at in the event of a data breach.
Okay, all right. And then just overall, what would you consider as the minimum compliance requirements when it comes to the Data Protection Act?
So the minimum requirements that we're looking at, one, I always say that the first issue that you have to look at is what is the lawful basis that you're using to collect and process based on the data. Is it constant? Is it legitimate interest? So you must be able to look at that and establish the legal basis. Then secondly, you look at the data protection principles that have been put in place, storage limitation, data minimization, security measures. Have I put in place adequate security measures? So on and so forth. So if you're able to demonstrate that I've complied with the principles, I do have a legal basis, and the way there is a requirement for me to do a data protection impact assessment, have I done so? then I think you should be able to demonstrate compliance. And again, with the local university on that, and we're developing a curriculum. So if you can demonstrate certification, I understand certain jurisdictions are offering certification programs for DPOs. Yes, I think that would also be a good thing for you to demonstrate.
Okay. And when you go in and